Hello everyone, I am SWAGATIKA BEHERA from KIIT University and currently I am working as legal intern in LEXCLIQ. So, today my topic is, can state make law for minority institutions under Article 30 of Indian Constitution 1950? The purpose of this video is to raise awareness of the minority institutions and how they preach their students. So, Article 30 of the Indian Constitution states the right of minorities to establish and administer educational institutions. It says, all minorities, whether based on religion or language, shall have the right to establish and administer educational institutions of their choice. So, it is said that every minority and minority representatives of India are free to administer their own educational institutions and teach their children as per their choice and want. India, being a secular country, has always advocated the principle of equality in the country. Protection of rights of religious as well as the ethnic minorities have been the backbone of the secular values of our country. Indian Constitution was adopted by the Constituent Assembly in 1949 and it became effective on 26 January 1950. Considering the factor of education and its need, the Constitution made certain provisions for the minorities to avail them with the benefit to establish and govern their own educational institution under Article 30. Where they can help the student form their community to give some privilege and support their education system. Article 30 is classified under the Indian Constitution, Part 3 of the Indian Constitution. It throws light on the fundamental rights which are given to the citizens irrespective of caste, religion and sex. Article 30 of the Indian Constitution is one of the many provisions which ensures that the rights of the minorities are preserved. Article 30 is classified under Part 3 of the Indian Constitution, which basically throws light on the fundamental rights which are given to the citizens irrespective of caste, religion and sex. It upholds the right of the minority community to establish and administer the educational institutions of their choice. Okay, basically now moving towards the features of Article 30 of the Indian Constitution. Article 30 of the Indian Constitution consists of provisions that safeguard various rights of the minority community in the country, keeping in mind the principle of equality as well. Article 30 Part 1 says that all minorities, whether based on religion or language, and shall have the right to establish and administer the educational institutions of their choice. Article 31 Part 1A deals with the fixation of the amount for acquisition of property of any educational institution established by minority groups. So this says that the government here can fix the amount and also in the regarding of acquisition of property, it can established by the minority community, it can be functional. Article 30 Part 2 states that the government should not discriminate against any educational institutions on the ground that it is under the management of a minority, whether based on religion or language while giving aid. So the government is required not to discriminate any minority based education institutions while granting or helping them with funds. Article 30 does not prevent state from imposing reasonable regulations to make administration of minority institutions transparent, said by the Supreme Court. The Supreme Court held that the states has the rights to introduce a regulatory regime in the national interest to provide minority educational institutions with well qualified. Minority institutions cannot ignore such a legal regime by saying that it is their fundamental right under Article 30 of the Constitution. If the central government or the state government brings some new schemes or regime or changes the structure of the minority educational institutions, in that case they cannot deny by saying that it is their fundamental right under Article 30. So government can make laws So government can also make laws for the minority educations under Article 30. Now, coming to further, we can say the 151-page judgment, a bench of Justice Arun Mishra and UU Lalit said that the regulatory law should, however, balance the dual objective of ensuring a standard of excellence as well as preserving the right of the minorities to establish and administer their educational institutions. Regulations that embrace and reconcile the two objectives were reasonable. It said, now the famous case TMA Pi Foundation case, where 11 judge bench foundations, they said that Justice Lalit, who authored the verdict, said Article 31, right of minorities to establish and administer educational institutions of their choice, was neither absolute nor above the law. So that's all for my topic. Please do like, share and subscribe. If you have any questions, any comments or any suggestions, please do comment below. Thank you.